Hello, I'm Professor Claire Germain from the University of Florida College of Law. And this class is part of the Global Students Introduction to the Law of the United States. Today, we're going to talk about legal traditions, the common law and the civil law. The United States is known as a common law country, but you may also know that most of Europe and Latin America are known as civil law countries. So what do these terms mean, and what does it mean in today's world? The common law and civil law traditions stand out among the variety of legal systems because they are known in countries which are advanced economically and pretty powerful. Now, they also are witness to a lot of history and culture, and they have much relevance today. As you can see from this map, this color-coded map from the University of Ottawa, in blue, you can see the common law countries starting in England. Then you can see Australia, New Zealand, the North American continent, the United States and Canada. And then you can see in blue, or part of blue, part of Asia, part of Africa. The civil law countries are indicated in red. So it started in continental Europe and then was exported to parts of Asia, Central and Latin America, and part of Africa. As you can see from the other colors, there are some countries in yellow which follow the customary legal tradition, some countries which are more oriented toward religion, a religious system like Muslim law, and then finally some mixed legal systems which have inherited features from the civil law, from the common law, from other tradition. So this gives you a rough indication of legal traditions. Now, why is legal history relevant today? A famous French philosopher, Pierre Teilhard de Chardin, said one time, "Everything is the sum of the past, and nothing is comprehensible except through its history." For the civil law tradition, which is the oldest one, we have to go back all the way to Roman law. Civil law comes from the Latin, ius civile, which means in Roman times, the law applicable to Roman citizens. And what happened in 533, in the 6th century, Emperor Justinian, who you see on this image, who was the emperor ruling over the Byzantine Empire, Justinian commissioned a codification of Roman law called the Justinian Code. And that compilation was kind of lost after the 6th century for a few centuries. But then it was rediscovered in the medieval universities. So starting toward the end of the 11th century in Bologna, Italy, medieval scholars rediscovered the text and started reading it and annotating it, commenting on it, and trying to use the Roman law principles and adapting them to contemporary needs. So what happened was truly amazing because scholars came from all over Europe. They studied the text and then they went back to their countries and they established universities. So they established the Sorbonne in Paris in the middle of the 13th century in 1253. Then they went back to Oxford, to Cambridge, to Spain, to other countries of Europe. And the text was in Latin, they read Latin, they spoke Latin, so it led to the formation of what's called a jus commune, like a common law of Europe. That corpus juris civilis, which became the body of Roman law, as you can see, you have the original text, which is in the middle, and then on the side, you see commentaries, which are also called glosses. And then further, you have additional commentary. And the book that you have here was actually printed in 1522, and it comes from the University of Florida Legal Information Center collection. So it shows you how much admiration the scholars of the time had for the Roman law principles and how they adapted them. So at civil law, then, we now know that Roman law was rediscovered in the Middle Ages at the universities, and law was developed as a scholarly activity by professors. So if you're talking about law as an academic subject, you're talking about a rule of law, a formulation of law, which is rather abstract. And it's still the case today. When you study law at a French university, a German university, a Spanish university, you're going to have a lot of lectures. Professors write a lot of treatises. When you want to read about the law, you read treatises. So it's still pretty much a scholarly activity. Let's skip over a few centuries after the medieval times. When the era of the nation state arose, then many countries codified their laws in the 19th century. So these codes were inspired by Roman law principles, by canon law, religious law, and by the natural law movement of the 18th century, law being the product of reason. And that codification movement gave rise to the French Civil Code in 1804, to the German Civil Code, which was more scientific in 1900. And the French Civil Code served as a model for other countries. And you can see the picture of Napoleon, who was the main architect of that French Civil Code. And interestingly enough, many of these codes were inspired by the organization of the Justinian codes. So it was organized of persons, of things, of property, of obligations. These codes encompassed the entire body of private law, dealing with the law relative to private persons. Let's turn away from the civil law now and go to the common law legal tradition. The United States is a prototype of a common law country. Its legal system and tradition is based on English law, and the law itself was formulated not in an academic way by scholars, but it was developed on a case-by-case basis by judges. How did that happen? We have to go back all the way to 1066 and the Battle of Hastings. You remember William the Conqueror, who was the Duke of Normandy, invaded England, became the King of England. He imported his strong lords and central administration. And then that's what started the royal courts. And then one of his descendants, King Henry II, Plantagenet, established the permanent royal courts in London. So that was a major factor. So at that time, then, the young lawyers, the law students, the judges read and studied the law not in the universities. There were universities, Cambridge, Oxford, but that was more for clerics, for academic topics. To learn the law, you went to the Inns of Court. So they were where the courts were, and they were called inns because the students stayed. They lived in those courts. They lived in those inns. And they still exist. Today, if you want to be admitted in the legal profession in England, you have to be admitted by one of the Inns of Court, different buildings. Now, at common law, the law it was born out of procedure. There is the notion of precedent, the principle which states that, or authority, if you have a case, it can be, that earlier case can be binding or persuasive on later decisions, subsequent cases. Students were trained at the Inns of Court, and in today's law schools, in an American law school, you learn the law by reading case books, not really reading treatises. The major works of the time were not treatises, but they were case reports. Like, for instance, this book that we have in our collection at the University of Florida, 1577. It's called La Grande Abridgment, which is kind of a mixture of French and English, and it's a case report. When you wanted to present a case in the court system, you couldn't just go to court. You had to have a writ which was authorized by the royal court. Like, for instance, here, a writ of trespass, which is one of the forms of torts. So that's also from the collection of the Florida Library. So no treatises were written in England until the 17th century with Edward Coke, and particularly 18th century Sir William Blackstone, who wrote the Commentaries on the Laws of England, which is really the first major treatise formulating the body of the common law of England. So you see in Europe, continental Europe, lots of treatises. In England, court decisions, and then finally in the 18th century, a major treatise. So two different legal traditions. Now, law is tradition, but law is also language. Now, do you realize that when you watch a movie like Miami Vice, a TV show, or another police TV or movie, many words that you hear come from medieval law French, also called Norman French. For instance, in the modern legal language, you will hear words such as trespass, voir dire, which means say the truth, which is the procedure which is used to select jurors for a jury. You hear grand jury, petit jury, plaintiff, breaking and entering, will and testament. All these words come from through the Duke of Normandy. They come through the French, and then it became part of the legal language of the royal courts during the medieval times, and then it continued up until today's time. Now, just for you to know, the reason there are sometimes two words to say the same thing, like breaking and entering, will and testament, it's because one is English and one is French. And many people didn't really understand that law French. But you know how it is with doctors or lawyers. They like to use terms that are esoteric, that the regular people don't understand. So that was part of it. Now, we talked about these different legal traditions, but today there is a convergence of the civil law and the common law traditions. First of all, in civil law, the code is built on the fact that it regulates relations among private individuals. But since the industrialization of the 19th century, government has intervened a lot. So there are a lot more legislation beyond the codes. In common law countries, there was not that much government intervention, but now there are a lot of codes. The United States has a US code, state codes, administrative regulations. That's one fact. Another fact is the constitutional review of legislation, which was not common in civil law countries where there was a legislative supremacy. But now there are constitutional courts in almost every country. Another factor is the emergence of supranational legal norms, especially within the European Union. All the countries, whether they're civil law or common law like England and Ireland, are converging, their legal systems are converging because of the international norms of the European Union, which is a brand new system which is in effect in these countries. So as you can see, there is also a blurring of the civil and common law traditions as to the results to be achieved in a westernized society. So some scholars are talking now about the importance of calling that tradition the Western legal tradition rather than common law, civil law. However, there are still significant differences in the mentalities, the legal reasoning method, the styles of argumentation, even the general organization and methodology of law, legal education, and judicial process. You're going to hear a lot more about how things are in the United States, and that will allow you to reflect upon your own legal system if you're a student from a different country. Some American and English law ideas that are useful, that are distinct, part of the distinct American culture. The first one would be the concept of supremacy of law, that even the state is subject to review according to constitutional standards. The tradition of precedent, and then also the notion of the trial as an adversarial trial, often before a jury, which is very different from the concept in civil law countries of a more inquisitorial trial led by the judge. In the US, in a common law country, the trial is led really by the parties. There is a clash between the parties. That's how the truth will emerge. So in conclusion, as you can see from our previous conversation, law is steeped in history and tradition. At the same time, the globalization leads to the convergence of systems. So you will hear more on this in the different classes to come. So I hope to see you next time.